On the 29th of July 2025, the Eastern Caribbean Alliance for Diversity and Equality, ECADE, made history for human rights in Saint Lucia. The case titled Theodule et al. V. The Attorney General of Saint Lucia resulted in the Eastern Caribbean Supreme Court deeming Sections 132 and 133 of the Criminal Code unconstitutional, that is, the gross indecency and Buggary laws respectively. The executive director of ECADE, Kenita Placid, said that yesterday's ruling was, quote, not just a win in the courts, it also represents a step towards justice for the many lives lost to violence simply for being themselves. It signals that our Caribbean can and must be a place where all people are free and equal under the law, unquote. Placid says, however, that the Buggary law will be reworded and remain on Saint Lucia's law books in a sweeping move to ensure that non-consensual sex through anal penetration remains criminalized.
Many people just put it as the law being unconstitutional, and in their head, this law has been taken off the books. And just explaining what that means is absolutely important in making sure we get the message right, we get the language right, and is sending this out. The Buggary law still exists. All it does is indicate that if two persons in private, 16 years and above, knowing that Saint Lucia law says age of consent is 16, it is now in conformity with other laws that already exist. But if you are going to engage a minor who is below that age, please note that it is still a criminal matter. And we want to be clear about this because this is not opening a floodgate like people believe.
Veronica Snack gave some insights into the post-emancipation colonial context of the laws and resultant discriminations against persons who engage or are suspected of engaging in same-sex intimacy.
These provisions, in effect, were never the laws of Saint Lucia. They were never the laws of Namibia, for example, that also had a recent decision some time ago. They were not the laws. They were introduced by the British to quote unquote control the slave population most of the time. And they have just remained. The problem with them is that it has now been culturalized by many persons, believing that it is part of our cultural identity, and that those persons who are asking for the repeal are promoting a Western, global North agenda, which is clearly not the case, considering that these laws were imposed on us during colonial times.
Snack characterized the ruling as decolonial in nature.
It's about decolonializing our laws, our constitution, our legislation. A lot of the things that we have on our books, we don't even know where it came from. And it is things like that made us realize, when you look at the history of our legal provisions, where they came from. They didn't even acknowledge us as Black people, as individuals. But yet we cling to those same provisions like as if they are part of us. I reject that entirely and completely.
The ruling was well-timed given that it comes only 2 days prior to Emancipation Day, a true testament to the fact that there were hardly any aspects of the existences of Black, Indigenous, and colored peoples which colonization did not impact, and thus liberation and decolonization remain ongoing processes even 46 years into an independent Saint Lucia. For Choice News Now, I am Cianna Dalsan.